Straight ahead on Law and Crime Daily. Closing arguments in Minnesota versus Kim Potter.
She chose to become a police officer. And she failed in that responsibility. She betrayed her badge, and she betrayed her oath.
The jury now deliberates the former officer's fate in the death of Daunte Wright. Plus, another settlement reached between a news organization and Nicholas Sandman after claims of defamation. And we're waiting for the jury's decision after the months-long trial of former Silicon Valley CEO Elizabeth Holmes. Then later to the East Coast, where the trial for Ghislaine Maxwell winds down. Will the socialite be convicted?
I'm Anjanette Levy in for Brian Buckmeyer, and with me as always is co-host Terry Austin. Well, the decision is now in the jury's hands after the defense and the prosecution made closing arguments in the trial of Kim Potter. The prosecution opened by saying that Daunte Wright will not be with his family this Christmas or any other Christmas for that matter. He is no longer with us. And prosecutors also said that Potter, a 26-year police veteran, was negligent and reckless when she shot and killed Daunte Wright during that traffic stop last April. Prosecutor Aaron Eldridge walked the jury through what happened on April 11th, playing the body camera footage frame by frame. Eldridge pointed out that Potter's decades of experience in firearms training, saying she was up to date on policies, but she was still rash and reckless. Before finishing, Eldridge reminded the jury this case is not about whether Potter is sorry, remorseful, or a good person. She told them to make their decision based on the facts and around Potter's choice to use force.
The defendant alone is responsible for her choices and her actions. Daunte Wright did not cause his own death. We're here because this was entirely preventable. It didn't have to happen. It was a tragedy of her own making. And it's not just a tragedy. It's manslaughter. That she was an officer does not make it okay. That she was on duty does not make it okay. That she shot him with her service pistol does not make it okay. She chose right instead of left. She chose wrong instead of right. She chose her gun, and she shot and killed Daunte Wright.
Following the prosecution, Potter's attorney Earl Gray got the jury's full attention during his defense's closing argument. Gray told the jury it was Wright's actions that caused this entire situation and that had he cooperated, it would have been over and he wouldn't have died. Gray emphasized Potter was allowed to use deadly force even though she didn't know it.
Another basis for acquittal for not guilty is the simple answer. Mistake. She made a mistake. Everything they were doing as good police officers until Daunte Wright took it upon himself to flee. He even left after he was shot. Purposely. We thank you for your careful attention in this case. And if you look at the evidence, the believable evidence, and follow the judge's instructions, it's not a difficult case. They failed in every element, miserably failed. And I hope that you come to the fair conclusion of not guilty based on the evidence. Kim Potter isn't guilty of these crimes.
Now, the defense objected throughout the state's rebuttal arguments, saying it wasn't really a true rebuttal because it was so prepared. But the judge overruled the defense's objections. Now, as you may recall, Kim Potter faces charges of first and second degree manslaughter stemming from the shooting death of Wright during that traffic stop in Brooklyn Center just outside of Minneapolis. This happened during the Derek Chauvin trial. Officers pulled Wright over for an expired tag. They determined Wright had a warrant out for his arrest. Body camera footage shows officers attempting to take him into custody. There was a struggle, and then Wright tried to take off. Potter then shot him in the chest when he got into his car. His car sped away, hit another cart, and Wright died. Potter maintains she accidentally pulled her service weapon instead of her taser. Closing arguments came after emotional testimony from Potter on Friday when she testified.
I remember yelling, "Taser, taser, taser," and nothing happened. And then he told me I shot him. I'm sorry it happened. I'm so sorry. I didn't want to hurt anybody.
Now, joining Terry and I today is former prosecutor Matt Mangino. Matt, thanks so much for joining us. I'm wondering, what did you think of the prosecution's closing argument?
Well, I thought the prosecution's closing argument was very effective. I mean, they made it clear this case is not about whether Kim Potter feels bad or whether or not she intended to kill anybody. You know, this case is about recklessness or criminal negligence. Is she culpable for her actions? And because of her long history as a police officer, and in fact, she trained police officers and was training a police officer on this very day, I think holds her to a higher standard. And, this, as the defense tries to say, was a mistake, but there's no, defense is not a mistake is not a defense in a case like this. And, I think that the jury has to sort through everything that they've heard in this case, but really focus on the fact that she's a trained police officer who trains other police officers. And was she reckless in her conduct on that day?
And Terry, I'm wondering what you thought of the defense closing argument. Earl Grey, always an interesting character.
Earl Grey's closing was the worst I've ever seen, Ann Jeanette, and I've heard hundreds of closings. It was rambling, it was incoherent, and frankly, it was offensive. He basically was simply saying that the scene was chaotic, that the officers were fighting for their lives, and that Daunte Wright caused his own death. Worst thing he could have possibly said. And frankly, he said that using either the taser or the gun was reasonable. Not a good closing argument.
Very interesting. We're going to see what the jury does with all of it, how they digest this, and what decision they come to. Thanks to both of you. Now we're moving on to the state of Colorado, and that's where there's a case where millions of people have signed a petition to reduce the prison sentence for a man who was convicted in a crash that killed 4 people and injured many, many others. Now, in 2019, Raul Aguilera Medeiros lost control of his 18-wheeler when his brakes failed. He came upon traffic that was stopped because of another crash, and instead of taking a ramp, he drove on the shoulder before crashing into several other vehicles. Aguilera Medeiros was found guilty of 27 counts, including vehicular homicide, last October. The judge in the case said his hands were essentially tied when it came to sentencing Aguilera Medeiros to consecutive sentences. Now, more than 4.3 million people are asking the governor of Colorado to reduce the sentence, calling the crash an accident. The petition claims the company that employed Aguilera Medeiros had several mechanical violations during inspections. The judge can actually reduce the sentence within 91 days after the Department of Corrections evaluates Aguilera Medeiros. Well, still ahead on Law and Crime Daily, we are in verdict watch in the federal fraud trial for Theranos CEO Elizabeth Holmes. But first, a 19-year-old man reaches yet another settlement with a high-profile news outlet.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back to Law and Crime Daily. A former high school student, a Catholic high school student, settles a defamation lawsuit with NBC nearly 3 years after coverage of him that he says defamed him. You may recall Nicholas Sandman was a student from Kentucky seen in this video that went viral back in 2019. Some watching the video felt he was smirking at and mocking Nathan Phillips, a Native American man. Sandman and his classmates were waiting on a bus after attending the March for Life rally in Washington, D.C. Many news organizations reported on the video and suggested Sandman was a racist. But a second video actually showed another group, the Black Hebrew Israelites, shouting racial slurs and other things at people in the area before the video with Sandman and Phillips was recorded. Sandman tweeted that the settlement with NBC is confidential. He has already settled other lawsuits with CNN and the Washington Post. So let's bring Matt Mangino and Terry Austin back in. I'm really excited to talk with both of you about this. Matt, I'll start with you. It's really hard to know, what exactly these settlements mean without knowing the terms. But does this third settlement lead you to believe that NBC knew that something that they did was wrong, that they may have actually defamed Nick Sandman?
Well, yes. I mean, there's NBC had felt some vulnerability as a result of this lawsuit. We know that two others were already settled with CNN and the Washington Post. But there's a lot that goes into the decision to settle a case, and sometimes it can be as simple as the legal expenses that might be involved in defending the case. Based on what the amount of the settlement is. We don't know that because this is a confidential settlement. But there's no question, if you're 100% sure, and we can never be 100% sure in court, but if you really feel strongly that you did nothing wrong, that you were merely reporting the news, you're going to go to trial, especially if there's a huge demand out there. But if you feel some vulnerability, you might be able to get out of the case a lot cheaper. You're going to go and try to settle a case.
And Terry, I'm wondering what you think Nick Sandman may have gotten out of this, if anything. What type of monetary settlement do you think he may have received?
And Jeanette, I think it's going to be below six figures, maybe, 20, 30,000, maybe a little bit more. I think it's hard to prove defamation against a media outlet. You have to show that there's a false statement and it was publicized and that there was some negligence as far as that's concerned, and that there were damages. And I think here, this was a matter of opinion. You're looking at a video. So I think defamation might have been a little bit difficult to prove. I think they probably settled just because they don't want to go through all of that exposure.
All right. Well, wouldn't we all love to know? I guess we'll just have to wait and see if we ever find out exactly what Nick Sandman got out of all of this. Well, coming up on Law and Crime Daily, the fate of Elizabeth Holmes now in the hands of the jury. We are back, and we are in verdict watch in the federal fraud trial of former Theranos CEO Elizabeth Holmes. Last week, the prosecution and the defense made closing arguments to the jury. The prosecution actually argued that Holmes had the chance to be honest about her company's blood testing, but chose instead to defraud investors. The defense countered, saying the government's case didn't give the full story, saying there were missing witnesses and that the case was more complicated than the prosecution said. Holmes faces 2 counts of conspiracy to commit wire fraud and 9 counts of wire fraud. Once touted as a company that would revolutionize blood testing, later tests found that there were many issues with Theranos' Edison device. If convicted, Holmes could face 20 years in prison and a fine of $250,000 plus restitution. Well, Terry, I'll start with you on this one. What do you think of the defense pointing the finger at Elizabeth Holmes' former boyfriend, Sunny Balwani? They really said he was the bad guy here.
I know, it's so strange, Anjanette. He's being accused of physically and psychologically abusing Elizabeth Holmes. She even said that he forced sex upon her. Now, he is 20 years older than her, and they met a long time ago when she was in high school. But I don't think that's going to work very well. I think that the jury is going to look at that as though she is just making up excuses, and it has nothing to do with the allegations in this case.
Yeah, and we certainly saw none of that in their text messages that we've reported on. Matt, where do you think this case is going? What do you think the jury's going to do with it?
Well, Maxwell is pretty confident that the jury is going to find in her favor, that the prosecution hasn't proved their case beyond a reasonable doubt. Hey, this case has been going on for 3 years. 11 weeks of testimony, 29 witnesses for the prosecution. I think the prosecution has done a very good job of trying to weave together why this jury should find Ghislaine Maxwell guilty. Oh, excuse me, Elizabeth.
Right, Elizabeth Holmes. So it's easy to get them mixed up, 2 federal trials. All right, when we come back, we are going to move on to the federal sex crimes trial of Ghislaine Maxwell. Jurors heard closing arguments from both sides. We will tell you what our legal analysts have to say about the summations when we come back. The jury is now deliberating in the federal sex crimes trial of British socialite Ghislaine Maxwell. Maxwell was a longtime companion of Jeffrey Epstein, and she faces 6 felony sex crimes charges. Prosecutors say she recruited and groomed young teenage girls for Epstein for sexual abuse. Epstein faced similar charges in 2019. He was found dead by suicide in his jail cell before his case went to trial. Closings came after more than 24 witnesses testified for the government, including 4 women who say they were abused by Epstein with the help of Maxwell. Maxwell didn't take the stand last Friday after her defense team called only a handful of witnesses. Prosecutors began closing arguments Monday by calling Maxwell a dangerous and sophisticated predator. Now, Law& Crime's Adam Klasfeld has been in the courtroom for the entire trial, and he spoke with us, gave us an update following the government's closing argument on Monday morning.
We were expecting this to be a kind of 6-week affair. Here we are in the beginning of the 4th week, and the government has just concluded its summation under the theme of it is time to hold Ghislaine Maxwell accountable. That's the pitch that Assistant U.S. Attorney Alison Moe brought to jurors, saying that Maxwell targeted her alleged victims, seizing upon any vulnerability. The prosecutor said that these stories, it was no accident that these patterns emerged. This was stories that match each other's. They went through the extensive evidence we've heard over the weeks, corroborating important details of each accuser's story. This is the time when prosecutors put all of the pieces of the puzzle together and try to anticipate and undermine the defense's arguments.
In its closing argument, the defense said the government is only going after Ghislaine Maxwell after failing to bring Epstein to trial. They ended by telling the jury Maxwell was only on trial because of having a connection to Epstein and that having a relationship with him may have been the biggest mistake of her life, but it was not a crime. So let's bring Matt and Terry back in. Matt, I'll start with you. They called 4 accusers, the government did. Is that enough for them to prove the case?
Well, yeah, that would certainly be enough to carry the burden of proof in this case. Their stories seem to be consistent. There was a consistent pattern here. What the defense has to do is really rail at the fact that some of these memories may have some bias to them. They may have been influenced by outside factors. And if you can put the credibility, the believability of those 4 accusers, create some doubt about that with the jury, you might be able to carry the day in terms of this defense. But it's important. Every case comes down to the believability and credibility of witnesses. Was it enough to attack with expert witnesses like Professor Loftus? The memory bias of these witnesses, and somehow was it impacted beyond what actually happened, but what was heard or what they talked about or learned about after the fact.
And we've seen Professor Loftus in many, many trials before. Terry, do you think that Ghislaine Maxwell should have testified?
I think it was a very good decision on the defense not to have her get on the stand. Matthew's right. It is her word against their word. And essentially, she could basically argue from her perspective. So on the one hand, you would think it would be good to get on that stand, but it's a very risky proposition. Under cross-examination, she will be scrutinized. She'll be asked, why did she travel with these young girls? What was the purpose behind that? And I just can't understand what her argument would be. What is the purpose? Who would take these young girls and travel to foreign places with them without their parents? So I definitely think it was a wise move not to get on that stand. I think it would have been a brutal cross-examination. And I don't think there's any explanation for why you are conducting massages. I don't think she could deny all of that. So good move to keep her off that stand.
All right, it'll be interesting to see how long the jury is out. Well, thanks, Matt, for being with us today, and thank you for